Today, I'd like to welcome our guest speaker, Henry Litton, who I'm sure is well known to you all. One of the leading lights of the legal scene in Hong Kong for more than 50 years. Appointed Queen's Counsel 1970, after a career as a successful barrister, going on to be the first barrister appointed directly to the Court of Appeal as a judge. Then when Hong Kong returned to China, becoming one of the first permanent judges of the Court of Final Appeal, and ruling on some of the formative landmark constitutional cases of the new era after Hong Kong's return to China. Since retiring from the judiciary, he has been an outspoken advocate for judicial rigour and discipline, having sat in his court many times as a court reporter for the SCMP in the 1990s. I can bear witness to the fact that proceedings before Mr. Justice Litton were indeed rigorous and disciplined. His topic today, Reflections on Judicial Independence, is a timely one. These are challenging times for the courts in Hong Kong. The recent jailing of the student leaders on a sentence review provoked a great deal of public debate, some criticism of the judgment, suggestions of political motivations behind the decisions which led to the jailing of the activists. It's a great time to have Mr. Litton back with us at the club. Please give him a warm welcome. Thank you.
Thank you, Cliff, a very old friend. An article in the Hong Kong Free Press published in August 2015 lists 6 challenges to Hong Kong's judicial independence. The first is, quotes, excessive workload of judges, and adverts to the matter of delay in the courts. Similar statements have been made by many other lawyers, including Sir Gerard Brennan, former Chief Justice of the Australian High Court. Excessive workload. Where workload is concerned, the pressure may come from external sources, such as substantial increase in the cases brought before the courts. Figures published by the judiciary for the period 2012 to 2016 show a modest increase in the workload of the Court of First Instance from 17,751 to 20,291. And in the last 3 years of those statistics, there has hardly been any change in the overall figures. The Chief Justice has been constrained to make acting appointments, persons who hold office but have no security of tenure, a practice deplored by some as compromising judicial independence. He has recently asked for more judges to be appointed and considers the present situation serious. But is increased workload the sole cause of the problem? Might it be that it is not so much a deficiency in manpower as the ingrained practice of the courts themselves that has created the problem? That a culture of prolixity and irrelevance has infused the system, sapping its strength, putting pressure on resources, and wasting taxpayers' money. Might it be that it is the serious erosion of the strict discipline of law that lies at the heart of the issue. If that be the case, the solution to the present crisis is not so much an increase in human resources as a radical change of culture in the courts themselves. That will not be easy. Every breakthrough to a new paradigm requires a break with an established culture. Human nature resists change. But what confronts Hong Kong today is indeed a crisis, to the extent that the chief executive is hampered, in some cases, in her constitutional duty of implementing the laws of Hong Kong as Article 48(2) of the Basic Law requires her to do. I will enlarge upon this later on. Over many generations, the discipline of law had resulted in a common law system which was lean and robust. This was the system that the two sovereign powers, the PRC and Great Britain, agreed in 1983 should continue in the Hong Kong SAR after the handover. I was a judge of the Court of Final Appeal for 18 years. During those years, I saw the common law gradually unraveling and drew attention to this tendency on several occasions, but clearly not enough and to no avail. The essence of common law. Common law is judge-made law. It springs from the grassroots of society. From the accumulation of individual cases, principles of law evolve. Like a pyramid, it is broad at the base, built on human experience, which then yields the theories and principles at the summit. The focus of a common law suit is on remedies based upon a thorough understanding of the underlying facts and issues. In many instances over the past 20 years, the pyramid has been inverted. A court starts the process of adjudication with legal theorizing, not with analysis of the underlying facts. Law is, quotes, discussed, unquotes, when no discussion is called for. The real issues get forgotten in protracted polemics. Philosophy displaces focus. Is there leadership from the top to arrest this trend towards prolixity? Take the Democratic Republic of Congo case in the Court of Final Appeal. The facts were straightforward. In the 1980s, massive infrastructure projects were undertaken by a number of Chinese state-owned companies in the Congo. Arising from disputes concerning those projects, an arbitral award amounting to approximately $30 million was made against the Congo government, with interest accruing at the rate of $24,500 a day. By May 2008, the debt had swollen to over $100 million. The company FG Hemisphere, a US company, bought the debt and sought to enforce the arbitral award against the Republic of Congo in Hong Kong. The core issue was this: does the principle of absolute immunity apply in the Hong Kong courts, or is it one of restrictive immunity? Among many nations of the world, the principle of restrictive immunity applies when a state engages in commercial activity. It can then no longer claim absolute immunity and may be sued in the courts. But of course, Hong Kong is not a nation. It is an administrative region within China governed by the Basic Law. There's no doubt about the position of the Central People's Government on this issue. It is that of absolute immunity. It asserts such immunity against all other sovereign states, and it in turn accords reciprocal immunity to those states. So the question arose, can the courts of an administrative region of the PRC under the Basic Law apply a principle of state immunity different from that of the sovereign state? The Court of Final Appeal, by a majority of 3-2, said no. It is not my purpose to discuss the merits of the court's conclusion. What I would draw attention to is this: the judgments came to 195 pages. They contain comments by authors from all over the English-speaking world on a diversity of subjects: judicial independence, recognition of governments, de facto and de jure, state immunity, absolute and restrictive. They cite cases on state immunity that go back 200 years in the United States and elsewhere, none of which equates with Hong Kong's unique situation functioning under the principle of one country, two systems. Taken overall, these citations constitute a considerable piece of research and scholarship and may perhaps be studied as such by lawyers all over the English-speaking world. The problem is that such citation can be endless. Why confine the authors to those in the English-speaking world? Japan on the east coast of Asia, Portugal on the west coast of Europe are also democracies, with many others in between. Why not find citations from those sources as well? The proliferation of authorities adds nothing to the validity of a point made. It simply increases the length and obscurity of a judgment. But the court seemed insensitive to this, or to the fact that the judgments plainly concern the Central People's Government, and to be understood must be translated into Chinese. I therefore ask this question: how many hundreds of hours were needed to perform that task? The input of senior judges with profound knowledge of written Chinese would have been necessary, for a matter of that importance could not have been left simply to court translators. How much manpower was spent on that one case alone? It raises a fundamental question. What role do judges play in the scheme of things? Is it to resolve real issues in as short, clear, and precise a manner as possible, or is it to engage in scholarship? Do judges function in a courtroom or in a lecture room? In Lam Siu Po against the Commissioner of Police, the Court of Final Appeal said that a disciplinary hearing must be fair, and added, quotes, "Inherent in every fair proceeding is efficiency and expedition," unquote. This is the standard the courts require of the executive branch of government. How do the courts themselves match up to this standard? First principles. In discussing judicial independence, it helps to go to first principles. There are three pillars of government under the Basic Law: the executive, the legislative, and the judiciary. The legislature enacts the laws which enable the quality of life as we know it to be maintained, that the streets are safe, traffic is orderly, restaurants are hygienic, buildings don't crumble, and so on. The courts, invariably the magistracies, enforce these laws by appropriate orders. The executive implements them by necessary action. The executive, the legislature, and the judiciary together form the government of the Hong Kong as they are. These are equal pillars that ensure peace and stability of the community. The courts do not stand taller than the other two branches, but work with them as equal partners to maintain the rule of law. Failure to appreciate this fundamental point has led to unfortunate results. In this talk, I give examples of cases which have done great harm to the rule of law in Hong Kong. I come now to the Pun Lin Fa cases. Now, Pun Lin Fa is a Falun Gong practitioner. She's involved in two cases. One, an application for leave to start judicial proceedings against the Director of Food and Environmental Hygiene, and a criminal case, a magistracy case, where she is the accused. Both cases concern the misuse of government land by Falun Gong practitioners by the display of posters and other material on public railings, MTR walls, etc., during what they call static demonstrations without the permission of the authority concerned. The Cityscape is a public resource valued in the community. A city's urban scenery defines its image and character. It is the backdrop to citizens' daily living. The control of the display of posters, banners, is vested in the Director of Food and Environmental Hygiene under the Public Health and Municipal Services Ordinance. Section 104A, subsection 1B, you see that reference in the roadmap I've given you, I hope, says, quotes, "No bill or poster shall be displayed or affixed on government land except with the written permission of the director." Stop. Section 104C, subsection 1, authorizes the director to remove such posters where no permission was sought or obtained. Section 104A, subsection 2, makes it a criminal offense for anyone contravening Section 104A, subsection 1B. Events leading up to Punlin Pha's two cases. For many years, Falun Gong practitioners had displayed posters and material on government land during their static demonstrations without intervention by the director. Things changed in mid-2012 when the director started to receive complaints from the public about the displays. Further, a group called Hong Kong Youth Care Association began to stage counter demonstrations, putting up their own posters and banners. Clashes occurred at some of the sites. The director felt constrained to act. Warning letters were sent out requiring the removal of the posters and other displays. The Hong Kong Youth Care Association complied. Falun Gong did not. Their response was that their practitioners had a right to make such displays, a right, they said, to freedom of assembly, demonstration, and speech, which required no one's permission. The director began removal action. This then led to the application for leave to start proceedings for judicial review against the director. Now, the core issue in those proceedings sought to be raised in Punlin Pha's application is this. Section 104A, 1, subsection 1B, is, she alleges, unconstitutional in that it contravenes articles in the Basic Law and the Hong Kong Bill of Rights guaranteeing freedom of assembly, demonstration, and speech. This is pure nonsense. The section empowers the director to control the display of material on government land. The purpose of the legislation is to preserve the cityscape. The Falun Gong practitioners were at liberty to display posters and banners during their demonstrations as they please, but not on government land, full stop. Plainly, the Basic Law and the Bill of Rights were not engaged. By Order 53 of the High Court rules, this should have been dealt with ex parte. The judge, hearing the applicant's legal representatives in chambers without vexing the proposed respondent to the application and dismissing the application immediately as the discipline of law requires. Such an application for leave is a screening process under the High Court rules. The whole idea is that the judge in chambers takes responsibility for the whole matter. If the applicant does not ask to be heard, the application can be allowed or dismissed on paper. In either case, no reasons need be given. Instead, Mr. Justice Poon conducted what he called a rolled-up hearing. He heard full argument from senior counsel on both sides and detained further written submissions after 2-day sittings and gave what he called a judgment in October 2014, dismissing the application. All that it adjudged was that none of the points raised by counsel was arguable, and it took the judge 60 pages to say so. The applicant, represented by 2 counsel with junior counsel and a firm of solicitors, was funded throughout by legal aid. What an appalling waste of resources. But the story of waste and abuse continues, involving the same Falun Gong practitioner, Punlin Pha. I come now to the criminal case in the Magistracy. In May 2013, a poster was stuck on the outside wall of the Chief Executive's office and an officer of the Food and Environmental Hygiene Department sought to remove it. As a result of what then took place, Pun Lin Fa was summoned before the magistrate on 2 charges. 1, obstructing a public officer in the performance of his duty contrary to Section 23 of the Summary Offences Ordinance, and 2, displaying a poster on government land without permission contrary to Section 104A, subsection 1B of the Public Health and Municipal Services Ordinance. This was a simple case of law enforcement in a magistrate's court, a court of summary jurisdiction with limited sentencing powers, yet has now dragged on for over 4 years with no end in sight. If the magistrate had performed its function as required in the magistrate's ordinance, the case would have ended within half a day. What in fact took place illustrates how erosion of the discipline of law undermines the system. The statute governing the magistrate's jurisdiction is clear. When an accused is brought before him on a summons, Section 19 requires him to hear the evidence, determine the matter set out in the summons, and, based on his findings of fact, judge the accused guilty or not guilty. That is the, quotes, whole matter, unquotes, as set out in Section 19 of the ordinance. It defines the magistrate's jurisdiction. Instead, the magistrate embarked on the consideration of what he called 2, quotes, preliminary questions of law. 1, was Section 104A, subsection 1, the permission section, inconsistent with articles in the Basic Law and Bill of Rights guaranteeing freedom of assembly, demonstration, and speech? 2, was Section 104C, subsection 1, the removal section, likewise inconsistent with those provisions in the Basic Law and the Bill of Rights? On the 30th of January 2015, the magistrate gave his ruling. He held A, Section 104C(1) was not inconsistent with the Basic Law and the Bill of Rights, and therefore the charge of obstruction could proceed. But B, Section 104A, subsection 1, was inconsistent with the freedom of assembly, demonstration, and speech, as guaranteed by the Basic Law and Bill of Rights, and was therefore unconstitutional. The magistrate called it his ruling, but it was, in effect, a declaratory judgment concerning the constitutional validity of that section, affecting not only the accused before him, but everyone else in Hong Kong, including you and me. A remarkable undertaking for a criminal court exercising only limited jurisdiction. So a matter of simple law enforcement in a court of summary jurisdiction became a major constitutional issue. The Secretary for Justice's criminal appeal. The Secretary for Justice required the magistrate to state a case for the purpose of an appeal to the High Court. This took a considerable time. Eventually the case, as stated, raised 2 questions. Question 1, whether it was permissible to an accused, by way of defense to a criminal charge laid under Section 104A, subsection 1, to challenge the constitutionality of that section, and whether such challenge would amount to a, quotes, collateral, unquote, challenge on the permission scheme of the director relating to the display of posters on government land. Question 2, whether Section 104A(1) was unconstitutional on the grounds of inconsistency with articles in the Basic Law and the Bill of Rights. Now, this permission scheme, the criminal case brought against Pun Lin Fa had nothing whatever to do with the director's, quotes, permission scheme, unquote, referred to in question 1. It became a major distraction and illustrates how far these criminal proceedings had spun into the realm of pure polemics. There are published guidelines for the exercise of the director's discretion under Section 104A(1), subsection 1. They evolved from events in the late 1980s when political bodies and candidates began putting up banners in prominent places. This led to clashes, particularly at suitable venues for such displays, were limited. Unregulated, this would have, of course, led to chaos. Over time, and after much public consultation, suitable places were identified, guidelines were formulated, limiting the size of the displays and the duration. The guidelines became known as the management scheme, administered by the Lands Department. The scheme applies to designated places for the display of material by members of the Legislative Council, the district councils and their committees, government departments, and not-for-profit bodies. Priority is given to legislative and district council members and government departments to promote events and campaigns. Designated spots are roadside locations. It was never Punlin Fa's case that either she or the Falun Gong Association had sought permission for their displays under the scheme or outside the scheme. So the so-called permission scheme in question 1, as raised for the appeal, had nothing whatever to do with the criminal charges brought against her. The outcome of the Secretary for Justice's criminal appeal, by the time the magistrate gave his ruling on section 104A, subsection 1, he had before him Mr. Justice Poon's determination in the judicial review case. It will be recalled that Mr. Justice Poon had held that the challenge to the constitutional validity of that section was unarguable, but undeterred, the magistrate ruled otherwise, that section 104A, subsection 1, was unconstitutional and therefore unenforceable in his court. The Secretary for Justice appealed against the magistrate's ruling, was then heard by Mr. Justice Chow, who gave judgment in August this year. In a massive understatement, he said, quotes, "The reasoning which led to the magistrate refusing to follow the judgment of Mr. Justice Poon is not clearly expressed and difficult to follow," unquote. One would have thought that Mr. Justice Chow would then have, in a few words, allowed the prosecutor's appeal, remitted the case back to the magistracy with a direction to determine the two criminal charges without further delay, given that the incident outside the chief executive's office had happened more than 4 years earlier. But not so. Justice Chow held that the magistrate did not have sufficient evidence before him on how the director's discretion, whether or not to permit the display of posters, is exercised to enable question 1 in the case stated to be answered. So the matter of the constitutional validity of that section, section 104A, subsection 1, was kept alive in these criminal proceedings to be further debated. Mr. Justice Chow remitted the case to another magistrate for fresh consideration. He added a remark that the determination by the new magistrate should perhaps be adjourned, pending the final outcome of the judicial review proceedings. But how is evidence regarding the exercise of the director's discretion under that section relevant to the charge against Punlin Fa when she had never invoked the exercise of that discretion in the first place? Now, therein lies another tale which demonstrates yet again how the cutting edge of the law is blunted and common sense displaced by polemics. For this, we have to go back to the judicial review case where Mr. Justice Poon had dismissed her application for leave, saying that none of the grounds was arguable. Undeterred, she, and still on legal aid, she took the matter to the Court of Appeal. And here's the twist in the tale. It will be recalled that the government had a management scheme limiting the display of roadside material to designated spots. The scheme expresses government policy. It seeks to protect the cityscape, in the interest of the whole community. It evolved over time after much public consultation, takes into account a variety of matters concerned with the quality of life in Hong Kong, including road safety. The courts have no say with regard to the merits or otherwise of such policy. And how the director exercises his discretion under the scheme is wholly irrelevant in Punlin Pha's two cases. The scheme had nothing to do with them, as neither she nor the association had ever applied for permission. But apparently not so, according to the Court of Appeal. Sustained by legal aid, as I mentioned, she appealed against Mr. Justice Poon's judgment to the Court of Appeal. The Court of Appeal agreed with Mr. Justice Poon that the grounds for applying for leave were unarguable. End of story? Not so. Astonishingly, the court allowed the originating application in Form 86 under the rules to be amended and a new argument to be put forward. The court held that two new grounds of a challenge advanced by counsel regarding the constitutional validity of that section that we now know well by heart, 104A, 1B, because the challenge were reasonably arguable because, one, no guidance is given in the ordinance on how the power of granting or withholding of permission is exercised, and two, the, quotes, proportionality test, unquote, might be applicable to the approval process under the management scheme or in relation to cases outside the scheme. These two arguments are far removed from the issues raised in her application for judicial review, and they are based upon the proposition that the Basic Law and the Bill of Rights are engaged in the first place. But remember this, Mr. Justice Poon had ruled that none of the grounds for judicial review was arguable, and the Court of Appeal had agreed with him. In other words, there's no logical connection between the restrictions imposed by Section 104A, 1B of the Public Health and Municipal Services Ordinance and the guarantees of freedom of assembly, demonstration, and speech in the Basic Law and the Bill of Rights. But the Court of Appeal seemed oblivious to this. The so-called new arguments put up by counsel are phantom arguments, and the court kowtowed to them. This is shadow justice, not real justice. The court ordered that the application for judicial review be remitted to the court of first instance for consideration, limited to the new grounds of challenge. Given the mind-boggling outcome in the judicial review proceedings, it is therefore not surprising that Mr. Justice Chow, in the criminal case, made the remark that he did, that there was not enough evidence for the question of the director's exercise of discretion under that section to be determined, remitting the matter back to the magistracy with that point in mind. The Court of Appeal's judgment went before the Appeal Committee on Punlin Pha's application for leave, still funded by legal aid. The committee adjourned the application, pending the matter being determined afresh by the first instance judge. So what of the criminal prosecution? It is certain, following Mr. Justice Chow's remark made on the prosecutor's suggestion, that the magistracy proceedings will simply stand adjourned whilst the judicial review proceedings start afresh in the court of first instance and grind their way through the judicial hierarchy, feeding all the while on legal aid funds. The criminal case arose because of a poster stuck on the outside wall of the former chief executive's office in May 2013. There's now a new chief executive in town. Will the criminal proceedings be concluded before her term of office expires? Few would bet on it. There's a strong presumption of validity regarding the laws as they appear in the statute book. Day in and day out, people in all sorts of occupation and in their private lives rely on these laws for their own safety, well-being, and to regulate their own affairs, whether they are aware of it or not. The 7 magistracies in Hong Kong deal with hundreds of thousands of enforcement cases relating to these laws. If a constitutionality defense can be raised in such cases as a matter of course, and magistrates are required to deal with them, the work of the courts would come rapidly to a halt. One would not need urban terrorists to bring civil administration to its knees, and Pun Lin Fa's case is a sobering example. The Court of Appeal had held that the new challenge to that section is, quote, arguable, so argument on a phantom situation will now rage in the courts for years to come. What purpose is served by such debate? What is more important to the community, effective law enforcement or theoretical niceties in the law? How much judge time has been consumed in Pun Lin Fa's cases, and how much more is to come? It's beyond the scope of this talk to examine closely the jurisdiction of the magistrates in Hong Kong and to trace how they came to exercise their function akin to a constitutional court. It appears to be a recent phenomenon encouraged by a series of ill-considered cases in the superior courts. I direct your attention now to the case of Secretary for Justice against Ocean Technology and 6 others, which concerns the use of radio spectrum, a limited resource strictly controlled by the International Telecommunication Union, which allocates part of the spectrum to member states, and China in turn allocates part of it to Hong Kong. There are multiple uses of the spectrum, including the police, fire services, and so on. In Hong Kong, it is regulated by the Telecommunication Ordinance, which, where relevant, and you have it in your roadmap, says Section 8, save under and in accordance with a license granted by the Chief Executive and Council, no person shall A, establish or maintain any means of telecommunication, or B, possess or use any apparatus for radio communication. Section 20 then creates a criminal offense for someone who offends. The defendants set up transmitting systems in various places, operating what they call a citizen's radio, transmitting on FM frequency. They had no license. When brought before a magistrate on charges under Section 8, the facts were not in dispute. The proof of guilt was obvious, but the magistrate acquitted them on the ground that the power given by the statute to the Chief Executive and Council was unfettered, and this infringed both the Basic Law and the Bill of Rights. This was total nonsense. The whole point of the prosecution was that the accused simply had no license, full stop. It was not a case where the Chief Executive had exercised his power to reject an application for a license. The Secretary for Justice appealed against the determination. The case went before a single judge. One look at the papers should have convinced the judge that the appeal must be allowed, but no, the matter had to be referred to the Court of Appeal. So another simple case of law enforcement in the magistracy was inflated into another cause célèbre. I come now to another case, which is the Secretary for Justice against Latka. It was a simple case, a simple prosecution under Section 63 of the Road Traffic Ordinance. Again, the facts were straightforward. In July 2007, a car was captured on camera going through red lights. In due course, the police sent to the registered owner, the defendant, a notice requiring him to disclose the identity of the driver. The defendant did not comply with the notice, and he was prosecuted. In due course, he appeared before a magistrate and pleaded not guilty to the charge. The prosecution proved, 1, that the notice was duly sent, and 2, the defendant never complied. When asked what he had to say, the defendant, who appeared in person without a lawyer, told the magistrate that the matter was one of principle and he would be guilty of, quote, civil cowardice if he agreed to provide the particulars of the driver as required. The magistrate, instead of proceeding to find the defendant guilty as charged, adjourned the proceedings. 3 months later, he gave his verdict, comprising 53 pages, in which he held that Section 63 contravened the Bill of Rights and dismissed the summons against the driver. The Secretary for Justice appealed to the High Court judge, who once again did not deal with the matter himself, referred the case to the Court of Appeal. So yet another simple case of law enforcement became another cause célèbre. Now, what conclusion can one draw from these cases? Plainly, the system of law enforcement had broken down. What conclusion can be drawn particularly concerning judicial independence? A white paper issued by the State Council in 2014 caused a number of lawyers to stage a silent march in protest. The Bar Association issued a statement saying that it was wrong for Beijing to place judges in the same category as, quotes, administrators, unquotes. In the white paper, the State Council said that judges had, quotes, on their shoulders the responsibility of correctly understanding and implementing the basic law, unquotes. Was this a reminder to judges that they are part of the fabric of government of Hong Kong, that in discharging their responsibility they should focus on the real issues which trouble the community and not indulge in esoteric points of law raised by lawyers? In other words, that the courts, together with the other two branches of government, quotes, administer the law, and in that sense, judges are administrators. Now, this is pure speculation on my part. But if that is the message sought to be conveyed by the white paper, it would be entirely appropriate. The Bar Association took the white paper as an assault on judicial independence. The possibility that it amounted to a mild and timely comment seems not to have occurred to them, that the culture of prolixity and theoretical irrelevance in the courts should change. Barristers, above all others, should have an open mind on such matters. So I try now to tie up the knots. Under Article 48(2) of the Basic Law, the Chief Executive is responsible for implementing the laws of Hong Kong and must account to the Central People's Government in this regard, Article 43(2). In the cases discussed, implementation by the Chief Executive of the laws in 3 areas of life has been balked: preservation of the cityscape, control of the radio spectrum, and maintenance of road safety. The Chief Executive, in regard to the first case, is simply unable to implement the law and will not be able to do so for many years to come. This means that until Punlin Fa's cases are finally resolved, no one can be prosecuted under Section 104A, subsection 1. People, including practitioners of Falun Gong, can with impunity stick posters, bills, banners as they please, irrespective of size, on government land. Through inefficiency and lack of discipline in the courts, practitioners of Falun Gong achieve ends which they fail to obtain through due process. The limitation period for prosecution in the Magistracy Court is 6 months, so it would be many years before they risk prosecution under that section. In the other 2 cases, implementation was grossly delayed. Much taxpayer money has been wasted on time-consuming polemics in the courts. Accumulated fat has clogged the vital organs of the judiciary, rendering the courts unable to deal with the malfunction in the magistracies where they assume jurisdiction over constitutional issues which they never possessed. Mr. Justice Ford said many years ago in a slightly different context, "I feel bound to observe here that the rule of law, upon which the protection of fundamental rights and freedoms ultimately depends, would have no meaning if a court were to assume jurisdiction not conferred upon it by the legislature. Assume that the Chief Justice, perhaps through the Secretary for Justice, were to approach the Chief Justice and say, look here, I'm unable to discharge my constitutional duty to implement the law. I suggest you take steps to correct the situation. Would this amount to interference with judicial independence? I suggest not. It would only be so if the judiciary takes the view that its role is to dwell in its own elevated sphere, detached from the real problems of Hong Kong society as a whole, that it matters not that the judiciary itself is the impediment to the due administration of law, and that it is endemic in the rule of law that proceedings should be tied up in knots created by the courts themselves. Thank you.
Thank you very much, Mr. Litton. Much food for thought after our lunch. We do have some time for some questions. Maybe I could get the ball rolling. You've talked about the judiciary's responsibility to take care of its own independence through discipline, through efficiency. In recent times, the courts have been operating in quite a difficult environment in Hong Kong, as I'm sure you're aware, with decisions in what might be regarded as politically sensitive cases, attracting much comment, attracting criticism. Some judges have even been subjected to threats. In the light of the recent jailing of the 3 student leaders, 12 eminent lawyers from outside Hong Kong issued a statement warning that Hong Kong's judicial independence was under threat and suggesting that the judiciary may end up being at the beck and call of the Chinese Communist Party. I'd very much like to take the opportunity to ask your thoughts on this, and how do you see Hong Kong's judicial independence in that sense?
I think you're talking about the sentencing policy of the courts. Now, there are really 2 cardinal points in sentencing. One, the court looks to the crime itself, its gravity, its effect on other people. Now, that is the first point of consideration. The court would then, secondly, consider such mitigating circumstances as exist, which might reduce the normal tariff which would be applied for that particular crime. But no mitigating circumstance can be so superior as to downgrade the crime itself. When it comes to crimes involving violence, and I think the cases that you're talking about certainly involve violence, because I think barriers erected by the police were broken down violently. And not only that, not only were people's life and limb put at risk, but people actually were injured. I think 12 were injured and 1 with some severity, I think. Now, given those circumstances, the principle requires the court to impose a custodial sentence. Now that's the first point. What mitigating circumstances there might be would perhaps reduce the term, but generally speaking would not change radically the type of punishment to something less than imprisonment. Now these are the general principles which I suggest apply to the case in question. And I have not, I regret to say, read the judgment of the Court of Appeal, which I believe comes to 60 pages. And my written Chinese has got so rusty that it would have taken me maybe 6 months to be able to read that. So I can only speak in terms of principles applicable to the duty of proper sentencing.
Thank you. Other questions? Gentleman over there, please. If you wouldn't mind giving your name, tell us who you are, please.
Fine. Mark Pinkston from Contact Hong Kong. To follow up on Mr. Bale's letter from the 12 jurors. Can you hear this okay?
Yeah. Can now if you...
Okay. One part also in that same letter is that the jurors had said that the Court of Appeal jailing of the 3 young activists was double jeopardy. Now, this is an argument which has been going around back and forth. Do you believe that in this case there was double jeopardy?
So this is the activists had been sentenced by the magistrate, had served the non-custodial sentence, and then sometime later prison sentences were imposed.
The principle that you're talking about, I think, is quite far removed from the situation in the present case. An appeal by the Secretary for Justice to the Court of Appeal could only proceed on the basis of an error of law, that in sentencing in the magistracy, the magistrate had not applied the proper principle relevant to the facts of the case. And constitutionally, that's how the matter got up to the Court of Appeal for its judgment. And it has nothing to do with the principle of double jeopardy that you're talking about.
Over here.
David Tweed from Bloomberg. I'd just like to ask you what your view is on how is it that Hong Kong's judiciary came to this stage that you're describing, this litany of inefficiency. What went wrong? What was the cause of that?
Well, I would suggest that you need to put me up in a hotel, pay my expenses for about a weekend, and then maybe I can answer that question. Not inefficiency, sir, but inadequacy.
Further questions? Over here.
Guy Shearer, Sai Kung Buzz magazine. Were the Chief Justice to create a post of Chief Whip, Mr. Litton, would you apply for it?
What is it the poet said? My eyes are weak, my limbs are frail, and I do not have the strength to wield a big stick anymore.
So second question.
Sorry, just to follow up on my earlier point. Of this letter, which the 12 jurors had written about double jeopardy and the independence of the judiciary, the 12 jurors were very eminent people, which included 2 or 3 members of the House of Lords. So they're very well versed in the law, in the rule of law. For them to make this comment, do you think that they have been ill-advised about what's happening in Hong Kong?
No. You can, if you like, criticize the legislature in enacting a law which permits that process to proceed in the first place. That is to say, that where there has been an error of law committed by a sentencing court, the Secretary of Justice has a right of appeal and to take the matter, therefore, on appeal. Now, inherent in that process, if you like, is this fact that the lower court, not only having imposed a sentence, that sentence may well have been served by the time the matter got up to the Court of Appeal. The Court of Appeal, given that constitutional power, is duty-bound then to deal with the matter. And in dealing with the matter, and if the court thought that another sentence should be imposed, such as, for example, imprisonment instead of community service, the fact that the appellants, the defendants, had actually served the term imposed by the lower court would of course be a matter taken into account when the Court of Appeal deals with the matter. So I can't see how the principle of double jeopardy comes into what you say at all. If that was not taken into account, then of course the Court of Appeal in turn might be said to have erred on a matter of law.
Well, that's basically my point, is that before them to make the comment, have they been misinformed or have they been ill-informed of what the actual case was?
Now look, this is a matter which is arguable. Some people may well say that, look, when it comes to sentencing, the court having discharged its function, as the magistrate did, that should be the end of the matter, and an appeal should only be allowed to the defendants themselves because of over-harshness of the sentence imposed in the first place, and that the government should not be allowed an appeal as well. And in legal circles, this is a matter hotly debated, and some might even say that a jurisdiction which gives to the government that power of appeal against a sentence is harsh and oppressive. Now, you're entitled to that view, but the law of Hong Kong is that there is an avenue of appeal open to the Secretary of Justice, which he properly exercised and properly took it to the Court of Appeal. End of story.
Okay, we're overrunning. I'll take a question.
Vote in England here. Just to summarise brutally, your implication seems to be that a lot of the trouble that might be seen at the moment for the judiciary to be doing its job is in a way self-inflicted, that they're doing it badly and it's taking longer, and this is where the problem lies. Rising above that particular issue, would you accept that the general environment in which this Hong Kong judiciary is now operating is somewhat different to 20, 30 years ago, and is in some ways perhaps more difficult?
Wow. That's really too general a question for me to be able to answer. I mean, to compare the general situation of Hong Kong as it exists today to that which prevailed 20 years before the handover,
Yes.
and the colonial era, well, I mean, it's beyond my capacity sitting here now to answer that question. I think
maybe I could clarify. that I think many of us who think and write about this sort of thing on a daily basis, here and now, have a certain kind of fear for judicial independence, which of course relates to the political situation now. And there can be lots of technical arguments about this case or that case, but I think there is a perception among some in the media and some in the judiciary that there is a sense of threat that didn't previously exist, that there is more intervention that was not desired, and so on. Now, of course, these are all sweeping generalizations, but of course that's what the media deals in. And it would be interesting to hear your opinion. You've functioned here before for a long time, you pop back from time to time, as to whether you would think it is a more difficult environment now to be a judge than at other times. Are there more threats to judicial independence now than there used to be?
The short answer is no. I do not see any threat to judicial independence in the situation as exists today in Hong Kong. Now, if you want an argument, I'm happy to put up an argument, but I'm not expressing an opinion. All right? Now, how independent, I ask you, were the colonial judges before the handover, who were sent from overseas to serve a term under the civil service regulations, the Chief Justice appointed from Whitehall? And wouldn't you say then that these judges were liable to be easily influenced by their paymasters in Whitehall? Would that be a viable argument?
It has been argued, of course. It could also argue that maybe they were more steeped in the common law than you would mind.
Well, what?
More steeped in the common law.
That you were expressing admiration for her.
That what the colonial judges were more steeped in the common law than they are now. Well, no, depends how you define the common law. I mean, the internet was not available to the colonial judges, and therefore they were not able to scour the reports, common law cases of New Zealand, Australia, India, Malaysia, various states in Africa. Now, are the judges more steeped in the common law now because... Well.
Okay, we can take just one more question. Gentleman over there.
I think in short you have given us some answers, but a very short one, and that is, should we be happy or unhappy about the way that the Hong Kong judicial system is developing?
Sir, happiness is a very broad concept and depends even on the state of your stomach, sir.
Well, thank you very much. We've already overrun.